The lyrics say, "Sweet little girls, only 2 and 3, they can't even spell custody. A year gone by and we still don't talk. One big open wound still pouring on salt." It's entirely accurate that kids have no idea. They have no idea what's going on when a divorce begins, when their parents are separating. And that's something that's difficult for a lot of litigants to really focus on because they see their life crumbling around them. But then the effect that it has on the kids. All right, welcome back to the No Judgement Podcast. Today we're going to be talking about a case between Austin Richard Post and Hee Sung Park. You may better know these characters as Post Malone and Jamie Park. Post Malone, obviously, world famous rapper turned pop star turned country star turned does a little bit of everything, right? Jamie Park, his longtime significant other, they share a child together. And following their recent breakup, Ms. Park filed a case for custody and support in California. And the interesting thing about this one is that Post Malone filed his case in Utah. And so clearly we can't have two different states that are addressing the same issue. So there is this thing called the UCCJEA. We like our acronyms because we use a lot of words. So the UCCJEA stands for the Uniform Child Custody Jurisdiction and Enforcement Act. And so basically what it does is it seeks to prevent what we would call forum shopping. So if one particular jurisdiction has more favorable laws as it relates to custody, child support, things like that, then a party may want to be in a particular venue. The problem with that is that state may not have jurisdiction. And so that's what's come up here in this case. So on this episode, we're going to be talking about what exactly is forum shopping, what is the applicability, or how does the UCCJEA apply? And then towards the end, I'd also like to talk a little bit about one of Post Malone's songs, which, although it doesn't directly relate to this particular custody battle, it has some really interesting lyrics in it that I found to be helpful and important in terms of discussing how custody cases can have an impact on the family. So, as it relates to this issue of forum shopping, Jamie Park, she filed in California. And relative to Utah, California has what I would personally consider to be more favorable child support laws for the person receiving support. They're more likely to get more money in terms of child support. And that's not a good reason in general to be picking a particular venue, just from certainly from a legal standpoint. But she chose to file in California. And the problem with that is that the parties had lived in Utah from at least January of 2022 to January of 2025. That's what Post Malone alleges in his response. And so the child was born in 2022. And so essentially what he's saying is that for the entirety of the child's life, that child had lived in Utah until they separated. And then at that time, they started doing what we would call they call it a nesting agreement, and it's not really what I would call a nesting agreement. To me, a nesting agreement is when you have one house and the child or children stay in that house, and then the parties sort of swap in and out of that house, right? Like a little bird's nest. So that's not really what was happening here. What they were doing was more of a shared custody agreement, to where the child was spending, at first, it was a week on, week off. Then they expanded it to 10 days on, 10 days off. I think one report that I read said they might have expanded it to 2 weeks on, 2 weeks off. Given the distance, that's not entirely surprising. But that they had expanded it, but that they were continuing to share custody of the child. Now, here's where the UCCJEA comes into play, because with that, first of all, the UCCJEA, it was put into place to avoid something like this, right? To have conflicting custody orders from two different states, or to have two different states trying to adjudicate the same issue at the same time. So obviously, you can see the problems with that. So what every state, with the exception of Massachusetts, did was they entered into this agreement. And basically what this agreement says is, here's some ground rules for how we're going to determine which state has jurisdiction. And the first determination is absent there being an emergency situation, because there are some provisions for if somebody is trying to escape domestic violence. And absent there already being an order in place, because then there's some specific rules related to that. But as it relates to this case, the first step is determining where is the child's home state, if you can. And home state has a particular definition as well. Home state is defined as the state in which a child lived with a parent or a person acting as a parent for at least 6 consecutive months immediately before the commencement of a child custody proceeding. Okay? So, what that means is, in order to have jurisdiction in this first example, the child has to have lived in that state for 6 consecutive months and then not lived in another state for 6 consecutive months. So what happens is, let's say the child moves, okay? They've been living in this state for over 6 months, which is what's at least been alleged here in the pleadings by Post Malone. Child lived there, let's just say, until January of 2025. Well, until July of 2025, whatever that date is, let's say January 2nd. So until July 2nd of 2025, Utah would remain that child's home state. And then if the child had lived in California for the 6 consecutive months, then on day 6 months and 1 day, California now is the child's home state and now has jurisdiction. There are provisions in there that talk about what happens if a child is going back and forth between 2 states. In that case, the original state is still going to retain jurisdiction. So why it's important here is that in his response to Ms. Park's filings in California, he alleged a number of things, the most important obviously being where the child had lived for at least 6 months consecutive prior to the filing. The other thing, though, that he kind of threw in there was that Ms. Park rushed to enroll the child in every activity she could in an effort to create a significant connection with California. So that's step 2. If there is no home state, then the court can look to which state the child has more significant connections with. So the problem for Ms. Park, though, in my analysis of this, is that she hasn't gotten beyond that home state question. And that is the first. The interesting thing about this, and not every statute is this way, but the way that the UCCJEA works, it lists in order which preference the court has as it relates to jurisdiction. So home state is listed as number 1. So that's the one that the court's going to stick with unless there's a really good reason not to. And in that case, it's usually one of those emergency jurisdiction cases. So the idea of getting the child enrolled in activities, trying to create connections, that's not something that's unfamiliar for somebody who's been practicing family law and has dealt with these sorts of situations. It's not uncommon to see that being attempted. And whether it's being done just naturally, hey, I've got to get a new pediatrician. We're in a new location. I've got to, enroll the child in childcare because I need childcare while I'm living here. A lot of times it's done innocently. It's done for logistical reasons because you just have to have some of those things. So, was she doing it in an attempt to sort of establish those significant connections? Was she doing it because those things were just necessities where she was living in this new living situation? Not for me to judge, right? The judge in the case might be judging that, but not for me to judge right now. But that's not uncommon to see the parent who's moved to start enrolling the child in new activities, creating some new connections in the area. But the important thing to remember is that doesn't matter until we get past this home state question. And in my opinion, just looking at this from the outside, and I haven't read all the pleadings, but looking at it from the outside, it looks like Post Malone probably has a pretty strong case here for home state jurisdiction in Utah. Some reasons why he might not want to litigate in California. Obviously, we already talked a little bit about the difference between California's child support laws and Utah's child support laws. So that's a sort of substantive reason, a legal reason why he might, strategically want to stay in Utah. The other is cost. And, you might be thinking, well, look, for a guy like Post Malone, right, headline Coachella, he's on a big tour right now with Jelly Roll. Is cost really an issue for him? And the answer might be no, not really. But also, I don't think anybody, whether it's you, me, or Post Malone, really wants to spend more money than they have to. And having to fight a custody case in another jurisdiction, there's travel considerations, discovery, if you've got to go for depositions. Now, a lot of times these days, in theory, you can do depositions virtually, but I know most attorneys aren't really big fans of that if it's not necessary. You like to have the other person in front of you. You can gauge a lot of things through body language, through how they respond. There's something about being in just one room together to where, that's a little bit, at least I find it to be a little bit better in terms of being able to actually kind of gauge the other person's answers, things like that. But also, like I said, the travel considerations, if you have court dates, you have to hire an attorney that's maybe in a different state. For somebody like Post Malone, who he's on tour right now, right? He's traveling all the time. So, the idea of traveling and having to travel and go away from your work for an extended period of time, for him, may or may not be all that difficult. For, your average person, for my average client, yeah, it can take a lot of time away from work, which you're trying to earn income, you're trying to make sure that you're able to pay for your litigation, and time off work is time that you're probably not getting paid for. So, and you're going to need those funds for child support, right? So Post Malone, his example may not apply specifically, but there are some things that sort of the average person, such as you or myself, might take into consideration when we're looking at things like jurisdiction and where do we litigate. So this kind of brings me, though, to his song. And this was kind of the first thing that really brought me to look more into what was going on in Post Malone's case. I honestly, at the time that I first heard these lyrics, the case hadn't been filed yet. The song is Two Hearts. And it's from his most recent album, his country crossover album, whatever you want to call it. But that's been out for about a year now. And when I first heard the lyrics of this song, I was like, first of all, it's kind of like, it hits you as a divorce attorney. Like, yeah, these are the things that my clients are going through every day. The song is about, I believe, I haven't talked to Post Malone myself. If he would like to come on, I'd be happy to discuss it with him. So Post, if you're out there, if you want to come, I'll meet you in St. Louis. All right. But the song, I believe, is sort of a tale of a divorce case. And so it begins with the lyrics, used to be two cars sitting in the drive. You had your dog and I had mine. Two sets of keys on a hook by the front door, but this house don't look like home no more. All right. And I do fully recognize how ridiculous it sounds as I just speak those lyrics and I'm not singing them the way that Post Malone did. But if you have a chance, I strongly suggest you go out and listen to this song because I think it's really good. But, it starts off and you think, okay, typical country song, right? Lost my dog, lost my truck, lost my wife, right? This sort of stereotypical country tale. But these are the things that people really experience in a divorce case. It goes on, white picket fence, fresh coat of paint, blacktop drive done turned to gray. You lose it all when there's nothing to lose. That's what happens when two hearts break in two. So, the idea of, losing it all. And that's something that a lot of people who are going through divorce feel is, I'm losing everything that I've worked my life up until this point for. And so, that's a very accurate portrayal of what a lot of people are feeling when they're going through a divorce case. Then it gets to the part that really starts to, I think, hit home, especially as it relates to a custody battle. The lyrics say, "Sweet little girls, only 2 and 3, they can't even spell custody. Oh, a year gone by and we still don't talk. One big open wound still pouring on salt." So here's where it really starts to, I think, hit home emotionally for the listener, because it's entirely accurate that kids have no idea, hopefully, but also sadly, they have no idea what's going on when a divorce begins, when their parents are separating. And that's something that's difficult for a lot of litigants to really focus on, because, they see, as the first part of the song goes, they see their life crumbling around them. But then the effect that it has on the kids, they don't know what a custody agreement is. They don't know why they're going and only seeing each parent half the time in an ideal situation, right? They don't understand these sort of things. And then he goes on to talk about the fact that the parents in this instance are not communicating. A whole year has gone by. They're still not talking, and they're still pouring salt on the wounds, right? There's still this bitterness. There's still this pain that goes along with the divorce process. There's another line that talks about, the next section talks about a for sale sign in our front yard. We only get half of what used to be ours, right? And that's what most people expect, and that's generally speaking what the court expects, at least here in Missouri. The outcome is going to be is that whatever property that you guys had jointly, you're each getting 50%. Okay, so very real, accurate portrayal of most divorce cases. But then it gets into, and we've touched on this before on this podcast, it gets into what I would call the mental health aspect of a divorce case. So the next lyrics are, there's a leak in my mama's house that's right above where I'm sleeping now. Dad's old shotgun still on the wall, trying not to give it a second thought. And so that's when, again, these lyrics really, I think, hit home for a listener, at least they did for me. And maybe it's just because of what I do every day, but it hits home of, this idea, the speaker here in this song is, contemplating self-harm, contemplating suicide because of the mental health toll, the taxing of this person's mental health in going through this process. And when you hear those lyrics of, the shotgun on the wall and trying not to give it a second thought, it really brings home how devastating this process can be for someone emotionally. And we've talked before about, if you're in that situation, if that is the impact that your case is having on you, how important it is to go out and get that help. Get somebody, talk to somebody, whether it be a psychologist, a psychiatrist, a counselor, a therapist, a trusted friend. It's important to address those and not just ignore them, because, without addressing that, you're going to be putting yourself in a terrible situation. And then reflecting back on the earlier part of the song, this person has kids, right? And the impact that could have on them. So again, something that is a very real consideration, a very real, accurate portrayal of how a lot of people feel when going through the divorce case. And then at the last section of the song, he says, "Hot sun beating through them dusty blinds. Only everything's what used to be mine. You lose it all when there's nothing to lose. Baby, that's what happens when two hearts break in two." And so here, the line, only everything's what used to be mine. So the speaker in this song, I used to have everything, right? And now I'm losing it all. And, sort of the juxtaposition of that between we only get half of what used to be ours, that half isn't really, a lot of times, most of the time, that half isn't half of the whole, right? Especially when you're talking about custody with kids, spending half of the time with them is not half of spending all of the time with them. And that's a very real thing that I think a lot of people, don't really think about before they go into a court case, before they go into a custody case. And so that's just something that, like I said, it really hit me. I found it to be, very compelling. It was one of those songs where, you listen to it and it's such a vivid portrayal of what goes on. Like I said, maybe more so because I see it every day. But to me, those lyrics, they really, like I said, hit home as far as the impact that a divorce case or even a custody case, when we're not talking about property, but the impact that can have on an individual. So just seeing how those lyrics came about prior to this whole custody battle, and then how things are now playing out with his custody case, my hope is that once they get past this jurisdictional issue, right, which in the scheme of things is sort of a, one of those procedural things that you have to go through. But once they get past that, my hope is, and it seems like they had been co-parenting fairly well. They worked out an agreement. They were sharing custody time equally. But once they can get past that, in terms of the jurisdictional issue, hopefully that will allow them to move forward smoothly. It'll be, one of those cases where it's just, they amicably co-parent, they're doing great. Kind of go back to, what we talked about with the Jason Sudeikis, Olivia Wilde case. Once we get past some of these court proceedings and the problems with, jurisdiction and some of those more legal issues, when we get back to the practical issues of sharing custody and how that's going to go, hopefully that's what these folks can do and can continue, I'll say, to co-parent very well. So again, no judgment for anything that went on here. Everything seems, pretty reasonable, although, like I said, the filing in California, I see it as sort of a nothing case. I don't really see it staying in California, but I'll be interested to see how the judge rules and what their basis for the ruling is. But until then, and until next time, no judgment here.